talk about the situation in their own country, and then for people because it's not quite there yet, but I'm just going to do a demo. But we can also get a training on that. So if I do it before.
Hello? There we go. Okay, so thank you for everyone to coming to this session, Manila Principles 1 year later. Quickly before we start, we have Slido available. So if you go to slido.com and use #RightsCon, you can put questions in, and then we will respond to those questions as they come up. So on the panel with us today, we have Kelly Kim from OpenNet Korea. We have Kenneth Carter from Cloudflare. We have Liesel Brenner from Global Network Initiative. And we have Eve Charon from Change.org and Danny O'Brien from EFF. And today for our session, we're just going to quickly go over the Manila Principles and talk about how they have been used over the past year. And then our panelists will share both how they've used the principles and different challenges that they see intermediaries facing, and discuss potential policy windows at which the principles can be used in the future. And then last of all, we will discuss a template notice that we've been developing to address or to provide intermediaries with a template on how to communicate content removal requests to concerned and affected individuals. So I'm not sure if everyone is familiar with the Manila Principles on intermediary liability, but they're a set of international principles that seek to set a baseline safeguards and procedures to guide the development of intermediary liability regimes so they're in compliance with international standards and human rights standards. The principles broadly are 1, intermediary should be shielded from liability for third-party content. 2, content must not be required to be restricted without an order by judicial authority. 3, requests for restrictions of content must be clear, unambiguous, and follow due process. 4, laws and content restriction orders and practices must comply with the tests of necessity and proportionality. And 5, laws and content restriction policies and practices must respect due process. And last of all, 6, transparency and accountability must be built into the laws and content restriction policies, and practices. And these were developed as concern around intermediaries and intermediary liability regimes have been growing, and they are meant to protect both intermediaries as well as protect, well, I guess most importantly, the freedom of expression online, and create an open environment for innovation. How they've been used over the past year, they've been presented at a number of different international forums. The Steering Committee for Manila Principles has been doing outreach to intermediaries to discuss the principles and ways in which they can be incorporated by different corporates. They've been presented to national bodies, including the Council of Europe. We've had a number of citations to the Manila Principles in different papers and reports, and we've been working on translations of the principles. The principles are available at manilaprinciples.org, and there you can see the broad principle, and then it will go into a description, and then you can click for further information, and it will describe and support each principle. So I think that's a very quick overview of the project. They were launched officially at RightsCon last year, so this is our second year at RightsCon. Which is very exciting. And from there, I think perhaps we can start with Ev, and you can talk about different challenges that intermediaries are facing and perhaps the application of the Manila Principles.
Sure. So yes, change.org is the online petition platform, and so anyone can create a petition about anything. And so, some petitions piss people off when they talk about removing a corrupt elected official, or when they talk about bad practices that a corporation does. We do get a lot of takedown requests from the targets of these petitions. And so the Manila Principles have been one of the guiding principles for us. And I say one of the guiding principles because, we, at the end of the day, have to comply with the laws of the countries where we have employees and where we have assets. And so, if the Turkey regime tells us, you have to take this down, and no, I don't have a court order, I'm an administrative body, and I'm going to block this content, there's not much we can do about it. So for us, the Manila Principles is more of like a standard, more an international public law where you're influencing regimes, and regimes that are on the fence, like Turkey or like Brazil, or that's where you can really lobby with those types of regimes. But I mean, even the EU doesn't comply with the Manila Principles because of the the e-commerce directive with the notice and takedown regime, and so. It's not always easy to apply the Manila Principles when you're risking, liability for your own platform. So we actually have a heat map of the world that is in my office. On most of the complaints that we get are about defamation. So we have a heat map based on defamation laws and intermediary liability laws. And we have the US green because of the Communications Decency Act, so there it's all good. We don't risk much. So then we can just apply our internal policies. Then we have all of Europe with the notice and takedown regime, which is kind of orange. When you get notice, you never know if it's sufficient notice or if it's not sufficient notice. So there again, it's not always easy to tell the claimant to come back with a court order, because when you come back with a court order, it comes back with, well, now you're liable and you have to pay damages. So it's putting ourselves out there in terms of liability for the platform. And then we have our court, what we call court order countries internally. And so that would be Latin America or other countries that do apply the Manila Principles, where it's very clear that we don't need to take content down unless we are ordered to do so by a valid judicial order. And then we have what we call our high-risk countries, and that's Turkey, Indonesia, Thailand, and those are ones where you risk your entire site being blocked or shut down if you don't comply with a takedown request. So that's kind of the reality. So we love the Manila Principles as a guiding star, as a North Star, but the reality is that we're not there yet everywhere in the world.
And I think just quickly about format, we'll just go perhaps down the line and then take questions. So Liesl, if you'd like to speak next.
Sure. So I am the Policy and Learning Director for the Global Network Initiative, which is an international multi-stakeholder organization of ICT companies, academics, investors, and NGOs and human rights organizations, such as the Center for Internet and Society. Thank you for inviting me to speak on this panel. Since its inception, the GNI has expressed its position that policies that create liability for intermediaries, for carriers, based on the content that they send or content that is posted by their users, threaten to chill freedom of expression, particularly where the definitions of illegal content are vague and overbroad, and that these incentivize self-censorship and prior restraints to speech. But today I'll just speak about 3 areas of our work that indicate some of the challenges presently facing intermediaries and that are related to the Manila Principles. First, there are an increasing number of proposals to hold ICT companies liable for content that may be deemed extremist, supporting terrorism, glorification of terrorism, using rather broad definitions of these terms. And last year, the GNI launched a policy dialogue on this subject, which explores this aspect of the issue as well as some other aspects. There is, of course, no internationally agreed upon definition of terrorism, and many of the laws that would apply in this context are extremely broad. And across the world, of course, counterterrorism laws have been used to silence political opponents, journalists, human rights defenders, and bloggers. A second issue is hate speech, which is an ever-present challenge for ICT companies that host or that transmit content globally. And while many countries in the world have laws that prohibiting hate speech, in order to determine which content is hate speech, context is essential. However, it's not uncommon for the companies to get pressure and overly broad requests to police hate speech, to kind of look at their platforms and figure out which speech is hate speech, and to take an active role in kind of determining whether this is hate speech. And then third, there's also increased action by some governments to influence the content policies of ICT companies, and then to use them to secure the removal of content through methods that are not necessarily transparent to the public and maybe lacking in due process. This is largely in the area of extremist content, but this also may occur with regard to hate speech as well. For example, the Counterterrorism Referral Unit in the UK obtains the removal of about 4,000 pieces of terrorist propaganda per month, and the European Union has established a similar referral unit. And so just briefly, I'll talk about the European Court of Human Rights and some of the European Parliament's efforts, which are relevant for these issues and for the Manila Principles. So last year, the Grand Chamber of the European Court of Human Rights held that in Delphi versus Estonia, that the contracting states to the European Convention can hold internet news portals liable for user comments that amount to hate speech or incitement to violence, quote, if they fail to take measures to remove clearly unlawful comments without delay, even without notice from the alleged victim or from third parties, unquote. And this is consistent with the right to freedom of expression in Article 10 of the European Convention on Human Rights. Delphi was a hybrid intermediary, one that produced content of its own and also hosted third-party content via user comments. And Estonia had determined that the domestic transposition of the e-commerce directive did not apply to such a hybrid intermediary, that it was instead a publisher of the comments rather than a host. The court, in this case, indicated that its holding was narrow, that it applied to, quote, a large professionally managed internet news portal run on a commercial basis, which published news articles of its own and invited its readers to comment on them, and specified that it did not apply to social media platforms. It found that Delphi exercised control over the comments for several reasons, but mainly because its revenue was linked to the number of comments that was on the site, and because the news portal established rules that kind of indicated to users how they could use the comments. Even though the holding was narrow, based on this reasoning, it might not be surprising if in the future the European Court kind of extended this ruling to different types of intermediaries. The court mentions the dangers of harm that is transmitted, or the dangers and the harm of content that is transmitted on the internet several times throughout the judgment. And its analysis of control is somewhat different of some of the analyses that at least the digital rights community would apply. And in its most recent case, MTE versus Hungary, it basically reiterates the Delphi holding and puts hate speech and incitement to violence in a separate category as defamatory comments. So then in November of 2015, the European Parliament issued a resolution on the prevention of radicalization and recruitment of European citizens by terrorist organizations, and spoke about how the internet and social networks are platforms that are increasingly used to radicalize and to recruit terrorists. And this resolution says, quote, member states should consider legal actions against internet companies which refuse to comply with an administrative or judicial request to delete illegal content on their internet platforms. And then it indicates that failure to comply may be considered an act of complicity. And it also recommends that EU member states should set up internet referral units, such as those that I referred to. So I'll leave it there for the moment, but those are some of the developments in Europe, where the European Convention on Human Rights and strong protections for freedom of expression are present, that are potentially concerning for companies that are participating in the GNI, companies that host or transmit user-generated content, and I'd be interested to hear your thoughts on how the Manila Principles apply to all of that.
Hi, I'm Ken Carter. Excuse me. I run legal affairs and public policy for a company called Cloudflare. For those of you who don't know us, we run a network, and our network sits between our 4 million customer websites and their customers. And our network makes their websites more secure and at the same time more performant. So we are the poster child for a pass-through and an intermediary. Our experience over the last year with the Manila Principles has been precisely 0. And that is probably for the reason we in the United States have the bigger brothers, or brother and sister, of the Manila Principles, CDA Section 230, and the Digital Millennium Copyright Act. So why don't I take a couple minutes to tell you about our experiences with intermediary liability, or it should be more accurately couched, lack of intermediary liability, and how we tend to handle these problems. So we have a written policy, which I would consider as being sort of the white space of the Manila Principles. So the Manila Principles say you ought to do this, you should do this, you must do this. Our written policy is that we will not take down a website based on political pressure. Full stop. What we mean by that is if you want us to take a website down, you have to come to us with a court order. That's not political, that's legal. A court order that specifies the website, the points of authority, notice and opportunity to be heard, all subject to all good principles of legal due process. We have never taken a website. We've never taken a website down for political process, for political pressure. We have had, in one instance, a court order brought to us, which required us to take the website down. I'll talk about that in a minute. But even if we do take the website off of our service, we're a pass-through. It's still out there on the internet. We cannot take it down. And that is among the reasons why we have such a strong policy around this, because it's ineffectual. I have told many a lawyer on the other side that I'm not firing a customer to give your client 30 seconds of joy before they return to the internet. So we see, let me talk a little bit about DMCA. We see 2,000 to 2,500 DMCA requests a week. And for those who, if I can digress for a second, the uninitiated, the DMCA is an act that came about in 1995, 96, so 20 years ago now, that gives safe harbor to intermediaries if they do several things like process requests to take down copyrighted material. Digital Millennium Copyright Act, to which we say, choose your law. You want copyrights, you want trademarks, pick one, not both. Right? We have CDA Section 230, it's the Communications Decency Act. This law also just passed its 20th anniversary, and it says, with the exception of intellectual property, that there is no liability for an online service provider. And it's not particularly well defined, but it's clear that it means hosts and ISPs and people like us. And we see increasingly organizations here in the United States that want to poke a hole in that. We were involved in a lawsuit, a trademark lawsuit last summer. EFF represented us in the Southern District of New York, where the recording industry in America tried to make us the trademark police for them. We have seen comparatively recently a lawsuit come out of Chicago where this was the, I gotta tell you, it was the raciest, spiciest, most salacious case I've ever seen. I can't tell you the facts, not because they're privileged, but because I'm afraid the plaintiff's going to sue me personally. But this was a crazy, crazy story. And one of the news outlets that published this was a customer. So what did they do? They sued us, they sued Akamai, they sued Rackspace, they sued Google, trying to get all of us to take down all of this content. And we had a conference call with opposing counsel, and I'm like, you understand that there is a total prohibition to your case. It's called CDA 230. And still, they persisted trying to get us, to bully us into taking the content down. And so we see all these little attacks. We recently saw a prosecutor in Alabama threaten us with criminal sanctions for not taking down a website because they objected to the content. We refused. So I can't go to Alabama. I'm persona non grata there. So maybe the Manila principles are applicable in the South. Let me leave it there, and we'll leave it, I guess, let the other panelists speak for a little bit, and then leave it open for questions.
Thank you. I am Kelly Kim from OpenNet Korea. We are a civil society organization established in 2012 in South Korea, and we fight for internet freedom and digital rights with the goal of making internet a platform for freedom, openness, and sharing. South Korea has been praised as one of the most connected countries in the world, and we topped ICT Development Index by the International Telecommunications Union last year, 2015. But unfortunately, this is why our state tries to rigorously censor and filter the internet, because it sees internet as a dangerous medium where harmful information spreads fast and the harm from the information is irreparable. And also the states depends on intermediaries to censor or filter those information. So they use intermediaries as their police. So it is very important that we have this Manila principles, as Liesl said, as our guiding star. Maybe, okay, as in Korea. So I will tell you about what did we do, what have we been doing with Manila Principles in Korea last year. Okay. Yeah, so this is Manila Principles. If you go to the website, you can read the principles, and it's in 9 languages, which is very nice because if you want to have your international principles on international impact, it should be accessible by those people using other languages. So it's in 9 languages, and there are 6 principles, and Alona already mentioned those principles, but if you look at it again, yeah, so. So if we compare the Manila Principles and our Korean notice and takedown regime, we have 2 notice and takedowns under Copyright Act and under Information Communications and Communications Network Act. Blue means it complies with Manila Principles. Red means it does not comply or it violates Manila Principles. So if you see, our Copyright Act is very similar to the MCA notice and takedown regime of the U.S. I would say it's not perfect, but it's if you look at the colors, it's generally in compliance with the Manila Principles. But Information and Communication Network Act Notice and take down under Information and Communication Network Act is very problematic because it forces intermediaries to just take down any information. Well, it says it's defamatory or privacy infringing information, but almost any information about a person or an entity, to take down those information if the person just gives a notice. So if you look at I get all mixed up. So if you look at the clause, so if the information, if the person alleges that the information intrudes on his privacy, or it's defamatory, or just any rights otherwise, the person can just send a notice to the intermediary, and the intermediary needs to take it down. And also, last year, Korea Communications Commission, which is a regulatory body for telecommunications, just proposed a law to reform this already bad law, to make it worse by not making it impossible for the intermediaries to restore those taken down information. So we saw it. So we fought hard against the reform. The proposed bill by KCC, and it has been successful because this is what we hosted intermediary liability. We hosted a international seminar on intermediary liability in last year's May, with Harvard Berkman Center, to educate our lawmakers about this international rules, especially Manila principles on intermediary liability. So we invited Professor Wolf Gesser from Harvard Berkman Center, and also Anupam Chandler, Eric Goldman, and Rebecca Gimlip, all those experts on intermediate liability. And the seminar was really successful. So many lawmakers came, and also we started a petition drive in June last year. We launched the petition at APR-IGF in Macau, and also Jeremy Malcolm from EFF visited Korea in July, and he met the lawmakers and other government bodies and intermediaries in July. So as a result, so cases, those regressive amendment has been stopped. So it was a small victory for us. But the problem is we also have we still have more laws which violate Manila principles. So like Korean law requires some intermediaries to implement technical measures to filter out copyright infringing material or obscenity or child pornography. So if you look at Copyright Act, Copyright Act, certain type of online service providers, special type of online service providers like P2Ps or web storage service like clouds, need to take necessary measures, such as technical measures that cut off illegal forwarding of the relevant work, which means like copyrighted work. So if you don't implement those technical measures, which is filtering measure, you can be fined. The intermediary will be fined like $3,000 US, maximum $3,000 US. And we also proposed a bill with a lawmaker to repeal this law. And also, under Telecommunications Business Act, under Telecommunication Business Act, any also those special type of OSPs like P2Ps or web storage services need to implement technical measures to prevent circulation of illegal information, which is obscenity, like porns. And also, if they don't implement the measure, they will be fined as well. And also, last one, and there's a Children and Juvenile Sex Protection Act, which requires intermediaries to take measures to detect child or juvenile pornography on internet, on their service. And if they don't implement those those measures, they can face like imprisonment by like maximum of 3 years, or like can be fined. So these filtering measures are clearly in violation of Manila Principles, as Manila Principles Article 1 states that intermediaries should not be required to monitor contents proactively. And also these technical measures are practically equivalent to general monitoring obligation banned in the EU e-commerce directive. So we are trying to repeal those laws. And there was this case. He's a former CEO of Kakao, which is one of the largest internet companies, like second largest internet companies in Korea. Actually, he was indicted under that act, and that was the first time that an intermediary was actually indicted for the violation of Children's Sex Protection Act, because like he didn't implement filtering measures for this chat app service for child porns. So there were these kids exchanging child porns on this chat app, and like our prosecution's office just indicted the CEO of Kakao, CEO of this intermediary, for not taking those measures to filter out child porns. How scary is that? So we criticized the indictment, and this is just a news article in Korean. And so we mentioned Manila Principles, and actually the news article also mentioned Manila Principles. And I think Manila Principles can help him to get acquitted, hopefully. So this is what we've been doing so far. And we think, especially notice and takedown for copyright or for defamatory or privacy infringing material, should be made no longer mandatory under our, like that is under our law. And because and also these technical measures, which are actually filtering measures, these requirements should be amended or interpreted so that they do not constitute a general monitoring obligation. So for the future of internet and the freedom of speech, we fully support Manila Principles, and it's been really helpful in our advocacy against this intermediate liability regime in Korea. Thank you.
So I think, first of all, thank you to everyone who's spoken for those examples of how the principles are being used, and also articulating the legal challenges that are being incorporated into regimes for intermediaries, as well as very realistic, or the realities of being an intermediary and the challenges that you face in that position. And of course, the South Korean case is very inspiring for us all, I think. And I think that actually your case study is on the Manila Principles website, if people are interested in going and looking at it further. I think we had some questions, actually. Maybe we'll just address those really quickly. I don't know how to get out of the ESC. ESC.
That's good.
Yeah.
They're both from me. I could just.
So-called anonymous.
So the first question is, what countries have implemented court order requirements for removals, especially interested in countries other than India, Spain, Argentina, and Brazil? Just off the top, I know Chile also has court orders. Yeah, for copyright. Are there other countries that we know of that do court order-based systems?
Brazil, okay, so you have
Yeah.
Argentina, Brazil, Mexico, and Colombia as well. I think are court order countries, at least for defamation. That's kind of it's our bread and butter at Change.org. More defamation than copyright.
And then also, if you go to the Manila Principles webpage, there's a jurisdictional analysis that does a comparative study of intermediary liability regimes on Chile, Canada, India, South Korea, UK, and US. That might, and also the Stanford CIS map. I think maps it out as well. The other question was, what legislative litigation threats to Manila Principles should we be paying attention to?
Well, given it's Daphne, I feel like this is almost a planted question because I know that Daphne's been raising and pointing out something that I think has drawn our concern as well, which is the otherwise very, very good. No? Okay, the general data protection regulations that have just passed, and one of the things that's sort of interesting in this area is that we don't usually think of data protection, or we haven't thought about data protection in this context because we've never really considered it to be something that was addressed at the traditional idea of an intermediary. But of course, as I think most people know about the right to be forgotten, but if the right to be forgotten is really just the first instance, I think, of this sort of application that people have seen more widely. And honestly, once you start looking through the data protection regulation through the prism of the Manila Principles, it actually does highlight some situations that I think we really hope will be clarified before we fall into a position of saying that these two things are in conflict. I think it's always the case that the trickiest moments with intermediary liability protection is when you have a case where it's tempting to reach for the intermediary because you have no other. You have it seems like you have no recourse. I think that Ken described the Delphi case, and you know one of the things that as a sort of individual rights organization that we worry about most in the Delphi case was the description that, well, the intermediary should be liable because the commenters were anonymous, and there was this balancing that took place there. Well, anonymity is very important to protect, and if anonymity is the switch that turns the gun of liability onto the intermediary, intermediaries have a very easy solution to that, and it's not protecting anonymity. It's making sure that no one who uses their service is anonymous any longer. And we know that that's one of those very fragile aspects of freedom of expression on the internet. And I think that at the same time as we have these challenging cases, the parts of this equation that I'm most sensitive to, and I think a lot of digital rights activists are sensitive to, is the intermediaries will respond, you know, to the law, and they'll do their best to comply and continue their businesses. The choices that they make, and the choices that they may make universally, may have extinguishing effects on particular forms of free expression that are very vulnerable.
As a follow-up to that, I do have particular examples that illustrate exactly what you're saying. So, you know, because defamation is gray, right? It's, you know, and no one knows, you know, whether the content is defamatory or not. it's, you know, it's kind of harder for claimants to jump through the hoops of proving that the statement is false and, you know, damaging to their reputation. However, it's very easy for them to say, this is my name, you know, this is my first and last name, it's my personal data, I have a right to be forgotten, take it down. And there's really not much we can do to combat that, other than if it's a public figure, and then, you know, we can have policies around that. But if it's not a particularly public figure, then that's true, there's not much we can do. So that's one illustration of that. And then, you know, the other illustration of that is indeed, you know, anonymity. And, you know, the pendant for us of a defamation claim is when the claimant does get a court order, and the court order not only says, take this content down, it also says, and give me the IP address and the email address and everything you have on that particular user. And that is a lot more chilling when we have to send a notice to our users and say, I'm so sorry, I received a court order, I'm going to have to give this information over. And in certain countries, there's recourse. So you can at least in your notice to the user, tell the user, this is what you can do in order to fight that court order. But in certain countries, like France, there is no recourse. And I've had to send an email to 12 of users for a petition that was perfectly legit. And tell them, you know, I'm going to have to take your comments down, and I'm going to have to give up, you know, give your IP address and your email address. That just feels absolutely awful. And that was a court order. There was just nothing I could do. So yeah, to me, it's even more chilling when, you know, you're giving up the data than just taking content down.
And I think at least in the Indian context, we see a lot of orders like that. Or, you know, when we've seen copies of orders, they tend to have that, you know, it's block this or remove this and give us the IP address. That we actually weren't aware that was happening until we actually started seeing copies of orders. So that was new for us, and I understand it puts the intermediary in a hard position. I think, you know, also always challenging. These principles, they apply to intermediary liability regimes. When you also have regimes, you know, multiple regimes in a context that allow for blocking of content, that can, you know, I guess in some ways it bypasses the liability regime. And we find that at least in India, the Indian government uses its blocking regime quite often to take down content or to order the blocking of content. And the punishment for challenging or not complying with an order from the government is 7 years in prison, so it's quite chilling. And I think that does challenge the Manila Principles, which specifically address liability regimes rather than blocking regimes.
Okay. May I add to that point? And there's a new anonymous question as well. Well, court orders are not always legitimate, and of course it has chilling effects. But in Korea, we don't need a court order to, takedown notices are given by private parties, any person. And there are like more than a few thousands of contents are taken down every day by those personal notices. So obviously, if you have to wait for a court order, it will take time, and it won't be like 1,000 or like hundreds of thousands notices like every day. So although some court orders can be legitimate or it's against the necessary and proportionate principles which applies to any freedom, any free speech. So I do think it's very important to make it mandatory to have court orders to take down any contents.
Just to quickly add to that, I don't know where to look for the person who asked this question, but okay. I'll just talk to the internet. We actually spent a lot of time discussing this during the drafting of the Manila Principles, and what we ended up, it's an attempt to describe to both allow you to criticize situations where court orders do go through a process that is clearly not impartial. And it's also, to be fair, part of the discussion was, we were saying, in some places, many places, the courts aren't necessarily where you're going to see true judicial authority being exercised. There may be administrative. We had a conversation again in the European context where people were saying, well, actually, administrative processes may have that power of judicial authority, and that may be legitimate. So yes, in some ways, we can't solve everything, and we can't describe procedures when the procedures themselves are broken, but we can try and point to allow people to talk about the ways in which they're broken.
And if I could just add to that, just briefly, the court order, I think, is an important check, but company action is potentially another check. The G&I principles indicate that companies that sign up to them when they receive government requests to restrict content will not accept informal requests, will request that the order be written, cite the law, signed by the official. They will try to interpret them as narrowly as possible so as not to restrict more content than is necessary, where it's appropriate and where it might have a chance of success, perhaps to challenge the order in court. And so there are potential other areas of checking the power of the government in that way.
Just from a pure statistical point of view, it does work, because when we do tell a claimant come back with a court order, 2% of the claims come back with a court order, which means like 98% of the claims don't come back and the content stays up. So it actually, like in practice, it does work. To ask them for a court order, it raises the bar. Now, is it perfect? No. I mean, there's inequality of access to courts. We see it all the time in the petitions. When a petition is against a big corporation, of course, they come back with a court order in 48 hours. And when it's against a small mom and pop shop, and it's a disgruntled employee that, creates a nasty petition, they, of course, so we have to then have our own internal policies of like, what is the right thing to do? But there is definitely inequality of access to lawyers and to courts, but at the end of the day, it still gets rid of the vast majority of claims to ask for that gold standard.
Can I just ask a clarifying question? Is the intent that the court order is against the intermediary or against the speaker, or either one?
So it depends. A lot of times people will give us a court order against Twitter, and it's not against, like, if the tweet is tweeting a link to our petition, then we'll say fine, we'll consider that the court's intent was indeed for this content to be removed. But a lot of times, it's these celebrated stories in the media. It's all over the media, right? Like some soccer player is accused of, sexual harassment. And it's all over the media, and there's a petition that says to the club, don't hire him back, or whatever. We had this case. And if the court order is against like some other media outlet for another article, I'm not going to take the content down. I would want a court order against, the particular content on my platform.
And if the question is about what the Manila principles think about this, I'm desperately trying to remember the conversations, but I think looking through it that it's pretty specific. That's aimed at the intermediary, because the risk is if you enter into a situation where court orders aimed at another individual can also sweep up intermediaries. Then, first of all, you don't get the specificity that you need, and you need. And you're looking so skeptical, and you need you need to be flagging that there is another process in place.
You want intermediaries to get sued.
That's one way to put it.
I don't mind being the subject of a court order if it's very clear that, take it down and then take it down. And so I know there's due process. I know a judge has looked at this and looked at evidence. Because, we work with no information. We have a petition starter saying, I'm correct, I'm truthful. And then we have a claimant saying, this is completely wrong. We have no power investigation of the matter. And, for an intermediary to become, the arbiter of truth, like, that's just impossible, nor is it something any of us would want the internet to be. And so that's our only way of getting to the truth, is having, a judge with discovery powers. And that's it. We have to rely on the justice system of whatever country, it's going in.
I'm just going to go to Bertrand.
I don't know if it's enough without a mic, but I still remember vividly the intense discussions that took place in Manila precisely on this topic. I think one way to get out of the debate that can be endless on yes, it's the perfect solution, no, it's not implementable, and both are right, actually. The way to get out of it is to hang more on one other expression in the Manila Principles, which is the notion of due process, because then you integrate the whole chain, and that goes back to what Lisa was saying regarding the content, the format for the request. I much prefer a very formally worded request according to a correct template with all the information to a lousy court decision that has been obtained in a country where the courts are not working properly. And vice versa, of course. But the key question that comes afterwards is, once you get a court decision in one country, what is the applicability extraterritorially of this national decision? So fundamentally, you get a court decision in country A. Should it apply to a global takedown, or should it apply to a partial withholding? What are the avenues for recourse afterwards? So you get court decision in country A, asking a platform in country B to take down a content globally. Where should the user whose content has been taken down go back to appeal the decision de facto by the company that has accepted to follow or not follow the decision of a local court? Do you go to the country where the local court has been edicting the first decision, or do you go in the country of the incorporation of the company? What are the costs for those things? So what I just want to highlight is that the notion of due process along the whole chain incorporates the entry point, the formats, the appeal mechanisms, and the whole escalation back and forth. It's probably a way to get out of an endless discussion otherwise. It will not be possible to implement all the time a court decision. It's a good standard, and I just want to caution a little bit against one trend that I sense sometimes, is that we have a tendency, because of the protection of rights, to consider that the only good answer to a request is no. And it's not true. There are very good requests that are coming from very, very bad countries, and there are very shitty requests coming from very good countries, actually.
Bertrand, to answer your question directly, our approach has been, if we get an extraterritorial judicial request, we will deny that request unless it comes to us through U.S. judicial channels. So I've done a letter rogatory in this job. I had to Google the word because I couldn't remember it from first year of law school. We have done MLATs.
Which goes to the fundamental question that in the end, because the operators are in the U.S., it becomes the U.S. law that applies worldwide.
Not always. There is another piece to this problem, that our network exists in a variety of different countries. I think we're in 39 different countries at this point. And each and every one of those countries is a sovereign nation. And some of them are rule of law countries, high freedom index countries, that may have a valid court order. And the way we work this out is that we work with our upstream providers, or telecom partners, or telecom hotels, and with the carriers with whom we interconnect, and allow them to implement filtering outside of our network, because we want to mitigate the negative impact, the collateral damage on everybody else, right? It's a really, really bad day if Cloudflare gets banned in a country it's a bad day for the one customer, but if it's everybody, it's a bad day for 4 million customers. That's a really bad day.
Was this your question? Oh, okay. So maybe we'll just take Carlos' question, and we'll go to this anonymous.
Yeah, I'm wondering, question was a comment. More than a question was a comment to contextualize it a bit better. Why that golden rule is there, and why there was all that discussion and second principle, wants to have judicial review. There is a trend that we've been witnessing, and maybe has not been raised yet, but that was part of our discussion, which is administrative enforcement of intermediary liability online. We've been seeing in the last 2 or 3 years the emergence of a number of administrative authorities that have been empowered with enforcement of a miscellaneous array of intermediary-related infringements. AGCOM in Italy for copyright enforcement, the Spanish IP committee. Then we have other institutions like TIB in Turkey, the KCC in Korea, the Rosoboronadzor in Russia, and they implement amorphous notion of infringement online. So the golden rule is there, I think. I was part of that debate, and I was strongly supporting for that, strongly supported the golden rule, because we've been witnessing this trend together with voluntary enforcement, which is the even more pernicious level of lack of due process.
So maybe we'll just quickly go to I think there's a question for Change.org.
So does Change.org implement partial withholding, i.e. through GeoIP filtering instead of global takedowns? So we have 18 versions or 19 versions of the site. So it is localized for a particular country. And so when we do a takedown, it is a takedown off of our entire platform. So it is, we don't do a takedown for one particular country. We usually do a takedown for our entire platform. What we do, though, to minimize also takedowns when we do a takedown, is a lot of times we will only take down a portion of the content. Because we'd rather, a lot of times, even if you delete a name from the petition still has strength and still has a valid advocacy point that it's making. And so we also try to, which is risky for us because we lose our intermediary status because, we're actually, at the position where we're working with the petition starter to just find a solution. But we prefer to do this because we have a mission that we're carrying. So, we want to be open, we want to be safe, but we also want to be empowered, because that's the mission of our platform. And so sometimes we actually will be okay to lose our intermediary status and to give advice to the petition starter, just instead of saying he's a rapist, why don't you say he's been accused of rape? That would be more accurate. And a lot of times that does the trick. So you also find these pragmatic solutions so that you get the claimant off your back and the petition stays up. So it's an imperfect game, and that's why we have internal policies as well. Because Manila principles by themselves wouldn't be all that helpful.
I think maybe we'll take this last question and then move to our template notice, because we'll just be aware of the time. So it says, on data protection, how do the right to be forgotten, how do the Manila principles apply to jurisdiction questions, such as the CNIL's fine of Google for not applying right to be forgotten demands globally? I don't have an answer to that.
I was there in the room, but I'm here mainly as Jeremy Malcolm's stunt double, and as all stunt doubles, I'm always put into particularly strenuous positions. Well, maybe Bertrand, can I bounce this back to you, because you have more of an eidetic memory than me. Where did we end up on jurisdiction questions? On this? Yeah.
Current situation is the following. There was back and forth, as you know. The first request was most targeted from the CNIL, the French Data Protection Authority, as the head of the Article 29 Working Party for Europe, to counter the argument of Google that initially said, we are not doing GeoIP filtering, we're doing local lenses. So basically, we're using google.fr, google.de, and so on. We accept to de-index for all the extensions in Europe, but we will not de-index for the extensions in .com and so on that are accessible in Europe. And so the reasoning by the CNIL was to say, no, you need to, any case, remove it from all the extensions accessible in Europe without more precision. And then Google said, okay, we will do geo-IP filtering. We will change our modus operandi from local lenses through CCTLD extensions to geo-IP. We will filter even on .com from Europe. And the position of the CNIL is actually to say, no, you should filter it worldwide. And the reasoning that a lot of people do not understand or haven't grasped because it was probably not expressed sufficiently. I had discussions with the people in the CNIL that I've known for a long time. Their reasoning is the following. The processing is a unique processing worldwide. And therefore, if this processing infringes on the rights of European citizens, this unique processing should be tampered with in order to respect the privacy right of those citizens. And therefore, the argument is not the accessibility in Europe. The argument today and the fight today is there is a unique processing, therefore it should be removed worldwide. Of course, this brings a huge question of extraterritorial extension of sovereignty. The problem is that, and I'd be provocative for 1 second, I don't agree necessarily with the way it's presented today. But I find it very interesting because it's the first time that the US actors are confronted with the mirror image of what a lot of European actors have felt for a long period of time. We had this amazing situation where every time a problem was emerging, it was, oh no, I'm sorry, the terms of service, we're based in the US, so it's the US law that applies. Do you have a problem with this? And this is extraterritorial extension of sovereignty as well. And so we are now in what, in the Internet Jurisdiction Project, we're labeling a legal arms race. And the problem is that there's a prisoner's dilemma situation where every single actor is trying on its own to solve this enormous conundrum of jurisdiction without talking to one another. And for people who are familiar with game theory, usually prisoner's dilemma, if people don't talk to one another, the outcome is pretty bad. And that's the current situation. So I don't know where it will go. Might go to court. The problem is a little bit, sorry to be long, but like the Microsoft case, it will go to court, but like in the Microsoft case and the Irish case, the court decision is a lose-lose situation. Because either one side or the other wins, and both sides will not solve the problem. In the Microsoft case, either it's an encouragement to data localization, or it's an extraterritorial extension of sovereignty. And in this case, either it condones a complete extraterritorial application of local laws, or it doesn't solve the jurisdiction problem in any way. So we don't know where it will go, I guess.
Worldwide. I mean, as an intermediary, you know, what is the ethical thing to do as well? And that's where, you know, I think platforms just have, you know, their own policies to look at and their own ethical obligations and kind of, you know, let the extraterritoriality issue play out. And, you know, the more as platforms we say, no, I'm going to try and, you know, tell the Berlin DPA that they don't have jurisdiction because the data processing is happening in the US, the more we're actually going to encourage them to try and go extraterritorial. And, you know, there's also a brand issue. How do I market, you know, my service to German citizens, tell them, come to my platform, you know, have petitions over there, and then tell them, but sorry, German law is not going to protect you because your data is going to be in the US. It's unattainable as a position as well. And so if you want to be global as a platform, you have to subject yourself to the laws where you do business. To me, it's just very simple, and it's just the right thing to do.
But if I may just piggyback on this,
yeah.
the core challenge is that, you're absolutely right, but the core challenge is that we're confronted with two fundamental tensions. One is, how do we preserve the global nature of the internet while respecting the national laws? And it's usually not a yes or no, it's a combination of the laws. Like partial withholding, for instance, is not law A or law B, it's both law A and law B on different territories. And the second element is that there are many cases of abuses and misuses, and how do we fight abuses and misuses without losing the human rights protection and that sort of thing. So just an answer to your comment on the right to be de-indexed. I think at the moment it's a very black and white discussion. And Daphne is raising often the question of, are there cases where it's legitimate to have global takedown? Hence my question earlier. And on the right to be de-indexed, I'm not sure that the same coverage, that's purely personal, but I'm not sure that the same coverage should apply to all requests for takedown. There are some elements that may justify to be taken down globally, and others that are so local or so minimal that, excuse me, it would be an overstretch, probably. So I think the fundamental principle is the ones that you mentioned, but the implementation will require a lot of discussion among the actors.
So I've sort of been channeling the spirit of Manila in my head about this, as well as like frantically looking through our background paper. And I think just having this conversation is very enlightening, because part of what you're talking about here is the freedom of the intermediary to make ethical decisions, right? And we're partly trying to make room here. But the other sort of part of this, that from the user's point of view, is increasing concern, because you give freedom, you give that flexibility to intermediaries, but then voluntary agreements come into place. And at the same time, as you know, if I'm a European citizen and I want European law to be played out, I don't necessarily want the intermediaries making those decisions in a way that's opaque and not guided by due process and the rule of law. So I think Pranesh is going to kill me. But I think that we can't solve all of these problems, right? And you know, you have to scope in something like the Manila Principles. But I think part of what we look for is some duty of transparency and explication to this, right?
Pound out the Manila Principles. The right to be forgotten came up, and we said, should we explicitly try to address these through these principles? And we said, no, it's going to be too much to try to. We'll let it play out a little bit more before we try to. And I mean, I almost feel like the right to be forgotten might need its own principles, just because they ask very specific questions that I think you're doing a really good job in articulating. But if you were to try to apply it to the Manila Principles, kind of along what Danny was saying, I do think Principle 4, laws and content restrictions, orders and practices must comply with the tests of necessity and proportionality, would be applicable, as well as Principle 6 on the transparency and accountability must be built into laws and content restriction policies and practices as very broad principles. Maybe not even all of those subpoints, because, you know, C under 4 is if content is restricted because it's unlawful, it should be done to the extent possible on a geographical basis. I can see Daphne's already disagreeing with me, so...
No, I'm disagreeing with Bertrand.
Okay.
So
this is the panel in exile over in the...
So I want to push back on the idea that data protection is so different that it should be uniquely eligible for global removal, because the class of claims that appear as data protection claims, and I know this from being inside Google when this all went down, is a superset of the class of claims that used to come in as defamation claims and common law privacy claims and all of these other things. But it lacks their common law defenses. And it is very often content that is not only legal, but valued and sought after, and people want to exercise the right to access that information in the rest of the world. So although it is the case that under data protection law, there's this logic that leads to global removal that is based on the idea that Google is doing its own processing, and this is about Google's action, and the question is this a single processing? Like, there's this whole logic that in data protection law gets you to a different outcome. In practice, if you're the one whose website has just disappeared from search results, it feels exactly like regular old intermediary liability and a regular old notice and takedown, and the procedural protections of the Manila principles are just as important.
I may have misexpressed myself, which is always interesting to have a comment afterwards, because you understand what people have understood you said, which was obviously not what I meant. I didn't mean that there is a specific rule for privacy protection that should be global removal and other things are different. What I meant is that in the right to be de-indexed, there might be more nuances and criteria than saying it's either global removal for everybody because it's a single processing, or it should be only local because, after all, it's Europe, and why not only France if you're doing it? So it was not a distinction between privacy issues and the rest. But sorry, I didn't want to. We can discuss that further.
What do you want to talk about? About court orders? Yeah. Oh, can I ask about court orders? Can I do that?
Apparently.
Moderator?
Yeah. Go, 2 minutes, and then we're going to quickly go and talk about our notice.
So I assume you guys see an array of court orders. Some of them, probably from trademark holders, are an ex parte order against a foreign defendant who wasn't there, and they got the court to name you guys the intermediary as being bound by the court order to take things down. When Google got those, it didn't like them, because getting a court order against you when you didn't have a chance to show up in court and say, explain CDA 230, is bad. But it seems to me that if you seek a court order against you as an intermediary, you are creating that situation. Like, do you seek to have someone sue you and then you show up in court, or do you seek ex parte orders? And I'll broaden this, and I don't have an answer, by the way. This is very messy. I'll broaden this by just flagging Ripoff Report, which is like the weirdest flower in the 1,000 flowers blooming for this, because they not only refuse to honor court orders and instead append them to the content that the court order refers to, they have, or did until recently have, their own private adjudication, and they will only take down if you go through their private adjudication because they trust it and they don't trust courts with ex parte orders. So kind of given that range of weird things that can go on with court orders, I'm curious, and can you look
sounds like the dictionary definition of totalitarianism, right? I'm the judge, jury, and executioner. Certainly one more story, and possibly two. So last summer, we got a court order from a very angry attorney in Washington, and the court order was adjudged against a no-show defendant, initial service of process of which had been served on a Gmail address. Right? I looked at this, and the court order prevented owning, controlling, transferring, or linking to a particular domain name, and it named a party by the name of Namecheap, who was a registrar. And I called the attorney back and said, I have your court order, I read it, thank you very much, goodbye. And he said, no, you have to take down the customer. I said, taking down the customer doesn't do what you want, they're still on the internet. And besides, this court order says not to own, control, transfer, or link to this domain. I don't do any of those things for sure, and I'm pretty sure that I'm not Namecheap. So go away and come back with a court order that defines our service and tells me not to provide service. Make me a defendant, or just go away. Take your pick. And they came back the Friday before Memorial Day with an order to show cause. This is when Mitch Stoltz stepped into the phone booth and put on his big red cape and big red boots, and we were off to the races. And we litigated. We got the first court order said you have to take down anybody who has any fraction thereof of the word Groove Shark in their domain name. So does this include, like Sharks and the San Jose Sharks? Well, it turns out the plaintiff, the legitimate website, customer. So now we're in a position where we have to make a determination whether or not we take down the plaintiff's website, right? Well, if you do that, that's what the order told you, but it's not what the judge meant. So if you do it, you're going to get a contempt order. If you don't do it, you're probably going to get a contempt order. Neither of those are good outcomes. So I called up, actually emailed the attorney in Washington, and I said, hey, I think this is you. Do you want me to take your client down? What do you want me to do? And he said, we're happy not to be a customer. I'm like, no. We'd love to have you as a customer. We think this is really cool that the plaintiff is a customer and the defendant is a customer. That's really cool. But I just don't want to get in trouble. And so stop being a customer. We took down grooveshark.li, grooveshark.io, and my favorite website, which was grooveshark-censorship.cf. And it was some guy in the Netherlands who had been following the case who put up a Cloudflare fanboy website. And we sent him a very nice note that we are under court order, that we're contesting the order to take you down. And we went back to court. We asked for a motion for clarification because now we are now the IP police for the recording industry of America, and you know, that's really not I don't think that's under the All Writs Act, right? And so the court modified the order that we had to have actual notice of infringement, or they had to come to us and say, hey, we've made this guy defendant, he's no, da, 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 da. So we went through all of this time and effort. Mitch was just heroic, and so is Corinne McSherry. Mitch was, in fact, a finalist for IP Council of the Year in the Bay Area for this work, quite literally. And we went through all this trouble and effort because it was the first time. And we wanted to set good policy. And I think we said okay-ish policy. Now that I have all the briefs and all the arguments and we've been down this road, I'm happy to do it again, just so that we get to the right policy. But there was a lot of time and effort that went into this to just make sure that we get it right.
Well, as you mentioned, GrooveShark. Actually, GrooveShark.com was blocked by our administrative censorship body, Korea Communication Standard Commission, for being illegal website where like copyright infringing materials are shared. So actually, we were trying to get that administrative order crushed, to get that administrative order to be crushed at court. So we were looking for plaintiff from anyone from GrooveShark, but like we couldn't reach them. So yeah, we couldn't go to the court with the case. But
I can give you their attorneys' names.
Okay.
So,
We're about 10 minutes over.
oh, we are. Okay, I thought we ended up at 4. Okay.
Nobody's gotten up.
Okay. This is like
I missed my phone call.
okay. Well, sorry you missed your call, but perhaps for the last 5 minutes, very
I
quickly.
am a remarkably fast speaker, so I will just so basically what's next for the Manila Principles, and what's next is partly to help out a group that we really haven't talked about much, which is smaller intermediaries. And the way that we're trying to think about helping them out is by smoothing out one of the biggest challenges for an intermediary in responding to these court processes that is useful for the end user who is the target of these processes. And that's, how do you convey all the information they need to really understand what's going on and their legal recourse. So the background here is that users are dropped into this situation. It's very unclear. Jurisdictions, as we've discussed, are very different about whether you must notify the person whose content is being removed, whether you actually, in some cases, can't notify the person whose content is being removed. There's no consistency. Any small intermediary, and again, one of the things I sort of want to emphasize is that this discussion is often placed at the multinational level, but there are many other intermediaries, emerging intermediaries, that we really want to be able to protect. There are problems with notices. Notices may be required where a legal process is followed, but not in almost nearly identical cases where content is removed under terms of service. I'll point people, because hyperlinking out is a good way of shortening comments. If you go to EFF's current project with visualizing impact, onlinecensorship.org, we're doing a lot of studies into content removed under terms of service agreements. And generally speaking, the survey that we've taken, users are simply not aware that they might have recourse, even within the intermediary's own systems, to put content up. back up. When they get a content restriction notice or a user deletion notice, they assume that's the end of it, and they're very distrustful of the intermediaries. We have a long piece, which I won't read out, but we try and spell out the level of transparency. And so what we wanted to do is create a notice generator to allow intermediaries who haven't thought about this as suddenly expanding around the world, how to explain all of these things. So it covers different areas of law, different legal regimes, and even the flexibility between different jurisdictions. We're not aiming at Google, Facebook, and the other giants who have worked very hard on this. There's still plenty to go in that area, and we have many interesting critiques of what these companies do to inform users who have content removed. But they already have the lawyers and the capabilities to do that. It's not legal advice, either to intermediaries or to end users. It doesn't prevail over anything else. We have a little flowchart which describes all of these things, including the user's rights and responsibilities and things that they can do in the future. And it gives them further information. It points them to resources that may be able to help, that aren't the intermediary, that aren't necessarily the courts, but can give them the support that they need to move on and challenge this in all the numerous ways that they might be able to do it. So we're going to generate a web form for this. I could go through that, but honestly, I think I want to give you guys the time to go on to your next thing. I will just, no, you know what, I'm not going to do it. But it will be available. We'll put up a little notice on the Manila site, principal site, and the FF site, and talk about this, and we'd love to get feedback from intermediaries and users. So thank you very much.
So
I know. Yes. Thank you so much for your kind words.
Yeah,